Turning now to Delphi, Indiana, where we are now in the third and final day of a three-day hearing for double murder suspect Richard Allen. Allen is charged in connection with the 2017 deaths of Libby German and Abigail Williams, who disappeared after going for a hike. Their bodies were found the next day in the woods. Allen has pleaded not guilty to those murder charges. The judge has not permitted cameras in the courtroom for these hearings. But Caitlin Kendall with Scripps News Indianapolis has been inside that courtroom each day. She brings us the latest on the developments from day 2 of the hearings. Take a listen.
Today, we learned about more than 60 alleged admissions of guilt made by Richard Allen in the form of over 650 phone calls, written communications, and conversations with others behind bars. It's all part of the defense's motion to have that evidence thrown out. It's all part of their request to suppress evidence of statements Allen has made while behind bars. It was a long day in court, 8.5 hours of testimony, a majority of which came from Allen's clinical psychologist while inside the Westville Correctional Facility. She said at times Allen would eat his own feces, bash his head against the wall, and even run from one end of the cell to the next to smack his head. Many of the times, she says he had to be given a form of a tranquilizer to stop what they called psychotic breaks. But much of that testimony was disputed by the state's witness, an ISP investigator, saying that many officers inside Westville believed that Allen's actions were fake. The clinical psychologist's intentions were also questioned by the defense after learning that she posted on social media about the case and admitted to talking with Allen about the case. The day wrapped up after testimony from the ISP investigator. He went into detail about some of the confessions Allen allegedly made, saying at one point he said he was sorry. We also heard in court comments about a number of times Allen has pledged his innocence. It's a lot of testimony that the judge has to take into consideration before issuing her ruling.
Now, among the remaining motions expected to be heard during today's proceedings is the state's motion in limine, saying in part, prosecuting attorney Nicholas McClellan and respectfully requests that the court enter an order requiring the defendant or his counsels to refrain from mentioning in the presence of the jury and during voir dire, opening arguments, presentation of evidence, and closing arguments, any and all references to the following, either directly or indirectly. Now, you remember, this was a big issue in the case: Odinism, cult, or ritualistic killing. Kagan Klein. Remember, he was someone who was thought to be involved in this, but was cleared of any involvement. Now, the redacted portion of that list includes the names of alleged Odinists that we cannot report on. All right, a lot going on in that trial. Important decisions to be made by the judge. He took it under advisement. Still with us to discuss, criminal defense and personal injury attorney Samantha Vacchiana and law enforcement and litigation expert Sonny Slaughter. All right, Samantha, let me start with you. Your thoughts on this idea that what the defense is claiming is that these almost 60 confessions to family, prison guards, other inmates who were sent to watch him when he was on suicide watch, psychologists, they're saying they amount to being coerced because of the conditions he was under. He was in a maximum security prison. He was in isolation for 23 hours a day. A lot of that time he was shackled. You heard some of the things that he was doing. I don't need to repeat them. So they're saying there were mental issues, but those mental issues were being caused by the conditions he was under and the treatment that he was getting, including the fact that a number of the prison guards wore Odinism patches. So you add that into the mix. Your thoughts on their arguments and what this judge might be doing and considering?
I think those arguments are valid, right? Given when someone is in isolation for that period of time, for that long period of time, given when the surrounding circumstances or the surrounding areas are such that they're almost inhumane, right? So I think here, some of those conditions that manifested are not unusual, and especially if he already had mental health issues. And some of those admissions and confessions, as they're being called, could be as a result of his environment. Sometimes people just want to go home, and they will say or do anything to get out of there. They'll tell you anything. So I think there's some validity to those arguments.
Yeah, and the rules suggest, Sonny, that they shouldn't be kept in solitary that way for a specific amount of time. I think it was something like 60 days or whatever. He was there for 19 months. That would drive anyone crazy. Think about that. So I want to get your thoughts on this claim by the defense. Now, I will say this. There was testimony from an investigator who said that at least one of the confessions that he heard had details that only the killer would know. Now, we've seen this type of thing before. There are ways to get information to people so that they regurgitate it later. I'm not saying that's what happened here, but that's not dispositive of the issue. But anyway, your thoughts on it?
I think both of you are correct in that I think the judge has to do this. You know, even though this man may have mental health issues and all of these things, and the crime may be heinous, we really have to protect the constitutional rights and process of individuals, whether they seem guilty or are guilty. The process does matter. I think the judge is taking the right steps to ensure that whatever happens in this case, that it has solid ground to stand on for any appeals that happen in the future. And the conditions are horrific in prison, and 23 hours a day, if he's not getting mental health treatment, the type of food and all of the other things can change who a person is and be impacted further if they have mental health issues.
And let's remember, he was in a maximum security prison 2.5 hours away from where his attorneys were. And again, he's not been convicted of any crimes, right? He belongs in county jail. The county said we couldn't handle him. We didn't have enough people to ensure his safety. So we ended up in maximum security prison. So that alone raises some flags for me. All right, so we know this whole Odinism issue, Samantha, very big for the defense. They claim that they have the goods. They can bring in a professor who will say, from looking at pictures of the scene, those are definitely symbolic. And this was some sort of ritual killing. It's going to be a big part, or they want it to be a big part of their defense. State's trying to keep any mention of that out. Your thoughts?
Well, yeah, the state's going to want to keep it out, right? Because it does bring doubt, if you will, reasonable doubt to their case, their accusations here. So, of course, they're going to want to keep that out. I'll be interested to see, and it will be interesting to see whether the judge will grant their motion in limine, because I think it is critical to the defense's case, and the defense has the right to protect their case and defend their case. And so in this instance, trying to keep out information that's valuable to the defense, I think the judge is probably going to rule for the defense.
Interesting. The state is saying, Sonny, that this would just confuse the jury. That they're, of course, trying to keep it out. The defense says we have a basis. You have to have some sort of basis to argue something. There is a following in the area. They know that. They have that testimony by a Purdue professor. They said the cops and also some of the folks in the prison guards wore Odinism badges. There was symbolism at the crime scene. What do you think?
I think the investigation should have been, had they done their due diligence, would have shown whether there was any evidence, factual evidence, to connect and tie in this particular organization with the murder of these two young girls, and if they've had similar crimes in the past that are subject to this type of oversight. Had they done their due diligence and it was thorough, if the defense has got somebody that can say that they've done their due diligence, then you have an argument. The defense has the right to do what they need to do to save their client, and the state must do what they need to do to prove that they don't have the evidence and that they have the right person in custody right now.
Yeah, and the defense is claiming they didn't follow leads, et cetera, et cetera. So we'll see how much of that gets in. All right, folks, stick around. Coming up next, we have 3 big cases happening tomorrow, including the sentencing for the father convicted in the Treadmill abuse murder trial. Details coming up when Court TV Live returns. Welcome back to Court TV Live. I'm Michael Ayala. Looking ahead to our calendar call, the father convicted in the Treadmill abuse murder trial in New Jersey will be sentenced tomorrow. A jury found Christopher Gregory guilty last May.
Madam Foreperson, has the jury reached a verdict?
It has, sir.
And is that verdict unanimous?
Yes.
Ma'am, I'm going to read to you each count. Please give me the jury's unanimous response. 1, how do you find as to count 1, endangering the welfare of a child?
Guilty.
2, how do you find as to count 2, murder?
Not guilty.
3, how do you find as to the charge of aggravated manslaughter?
Guilty.
Prosecutors say 6-year-old Corey Michelow died from injuries that he suffered from chronic abuse. A key piece of evidence was surveillance video showing Corey running on a treadmill as his father increased the speed. In the video, Corey is seen falling multiple times, and Gregor can be seen grabbing the child by the shirt, putting him back up on it. It was also a case of dueling forensic pathologists who had differing testimonies for the state and the defense about how Corey died. The state's witness called it homicide, while defense witness famed forensic pathologist Dr. Michael Bodden rejected those findings.
The presence of contusions on the back without a pretty clear-cut explanation it's not diagnostic of abuse, but it's very suggestive of abuse, certainly given the company that it's keeping. So my concern was not so much with the severity of the bruising, but the pattern and distribution of the bruising as being suggestive of child abuse. Corey Michelow died of blunt impact injury of the chest and abdomen with laceration of the heart, contusion of the left lung, and laceration and contusion of the liver. It's a traumatic cause. The manner of death is homicide. It was at the hands of another person. He didn't do it himself, and it didn't happen accidentally.
Did you review the autopsy photos?
Yes.
Did you review any police documentation?
Yes.
Okay. Did you review a 33-second video that was taken on April 2nd, 2021?
Yes.
Okay. Did you review a photograph of Corey asleep in his father's arms on April 2nd, 2021 at approximately 2:02 in the afternoon?
Yes.
Did you review a Dr. Andrew report?
I did.
Did you review a Dr. Feingold's report?
Yes.
Did you review a video of a treadmill from a gym on March 20th of 2021?
Yes.
Did you review an additional video from the same gym taken on March 29th, 2021?
I did.
Okay. Now, do you have an opinion after you reviewed all the material in regard to Corey's cause of death?
I do.
Can you tell the jurors what that opinion is as to Corey's cause of death?
I think that Corey's cause of death has been confused because of extensive injuries caused by the CPR process.
Gregor faces up to 40 years in prison. Now, we will be at that sentencing tomorrow and bring you all the developments. All right, we're going to go now to Georgia, where the man accused of killing a nursing student who was jogging on the University of Georgia campus in Athens last February will be in court for a status conference tomorrow. One local television station reports Ibarra could decide if he wants to take a plea deal or go to trial. Now, Ibarra was arrested on February 23rd, a day after Laken Riley was found dead. Now, he's been charged with multiple counts, including malice murder, felony murder, kidnapping, and aggravated assault with intent to rape. Police called it a crime of opportunity. Ibarra is still in jail with no bond. Officials say he is from Venezuela and was in this country illegally. And finally, pop star Justin Timberlake will be in a court via Zoom tomorrow to be rearraigned on his DWI case. Now, last week, his attorneys appeared in court and asked that the charges against him be dismissed. They claim that the singer was not intoxicated during his arrest and argued police made several errors in the case. The district attorney's office said it was just an administrative error in the original filing, and they still plan to prosecute. Timberlake, did not appear at that hearing because he was performing. He's on tour now. He was in Poland, but the judge ordered him to appear virtually for tomorrow's hearing. Timberlake was arrested for DWI the morning of June 18th in the beach town of the Hamptons in Long Island. He told officers he had had only one martini. All right, still with us to discuss is criminal defense and personal injury attorney Samantha Vacchiana and law enforcement and litigation expert Sonny Slaughter. Samantha, I'll start with you, and we'll start with Justin Timberlake. Interesting stuff there. Apparently, and they keep mentioning this, the defense does, that the officer who arrested him was young and inexperienced and was part-time. That was part of the problem with the first information or the first criminal complaint. It wasn't signed by a supervisor. It had to be. They corrected that. There shouldn't be a problem. But Justin didn't take a breathalyzer at the scene. What do you make of that? Is that something that's going to cause a problem, or is it helping him in this case?
Well, it's on both sides. As a defense attorney, if my client doesn't blow, as we say, it's good for us, because then all you have, and good for us meaning the defense, all you have is what the officers say that he observed and smelled and all that kind of stuff. It's also bad, right? Because you don't have that scientific evidence to say that it was below the legal limit or above the legal limit. So it can go either way. But in someone like Justin Timberlake's situation, being very famous and so forth, you know, people may believe that the officer is young, inexperienced, and just kind of made a jump to charge him or to accuse him because of that inexperience.
Yeah, we just saw his mugshot. Maybe we can put that mugshot back up again. I can tell you, there it is. Now, I'm going to tell you what else they have. They don't have the breathalyzer, but what the cop put in the complaint was they watched him run a stoplight. He was swerving multiple times. He was crossing lanes. The eyes were bloodshot and glassy. Icy, bloodshot, glassy eyes. Strong odor of alcohol on his breath, and poor performance on field sobriety tests. Sonny, that sounds like a conviction to me.
Well, at least it sounds like that they have the makings of a conviction, and that they have the opportunity to convict based on what the officer placed in his report, and the fact that the officer now has to take the stand. So my concern is, if the officer was young and inexperienced, they need to ensure that this particular officer is prepped and ready to go and put out factual information that the jury or the judge can understand as to why he is being charged with this and what the officer saw. You know, as an FTO, field training officer, it is really important to get the documentation right. And so far, it looks like the documentation is right, but they still have to prove their case.
Yeah, no doubt. And you know what she didn't see? She didn't see a superstar, right? She didn't see the aging superstar that he is, because apparently she didn't recognize him. So that might play into it. All right, let's go back to New Jersey versus Gregor. Samantha, he's facing up to 40 years. It was an ugly case, but there is an argument to be made that, you know, he bears the burden. You know, sometimes you have a mother and a father, you have grandparents, you have all those things, clearly, but he's the father, and he's going to bear the burden of killing his only son. He's facing 40 years, 30 on aggravated manslaughter, 10 on endangering the welfare of a child, and he's subject to the terms of the No Early Release Act, so whatever he gets, he's going to do. Where do you think the judge might fall?
I think here, because of those videos that we saw, right, of the young boy his son on the treadmill, and him really showing no mercy, I think the court's going to show him no mercy. I think he's probably going to get the max, the 40 years, because when you look at that video, that is not the actions of a father. That is someone who's basically a bully, and bullying this child that's much smaller and obviously, you know, defenseless against him.
Yeah, that part there where he's biting the kid on the head, that gets my ire. Sonny, quickly, your thoughts on the sentence in this case?
Same. I'm so outraged every time I see that video. The way he bites down on his son's head, he deserves the max. Day for day, door for the door, and that's it. It's a wrap for him, too.
Yeah, but not much else to say there, absolutely. All right, we're going to take a break, folks. The jury finds a man who punched and killed a stranger that he believed would go to hell because of his tattoos. They found him guilty of felony murder. We're taking a look at your comments on the Wisconsin versus Seymour trial and the guilty verdict there. We'll have your thoughts when we return. Keep it here on Court TV.
One of the most successful true crime TV shows ever.
This is crazy.
Now has a new home on America's original true crime obsession, 48 Hours on Court TV. Coming up next on Court TV.
Tonight on Closing Arguments, a Massachusetts woman stands trial for the stabbing of her husband and the long unsolved murders of 2 Indiana teenagers. A deep dive into the Delphi murder case.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Court is going to ask the clerk to read the verdict.
We, the jury, find the defendant guilty of felony murder, aggravated battery with the intent to cause bodily harm as set forth in count 1 of the information.
It is time for today's Talkback segment. You just heard the verdict in the tattoo punch murder trial in Wisconsin. Defendant Kevin Seymour was convicted of felony murder after he punched and ultimately killed a complete stranger because he allegedly didn't like his tattoos. According to court documents, 39-year-old Joshua Davies and his wife got up to leave the bar to avoid the confrontation back in June 2023. But 64-year-old Seymour followed them, allegedly punching Davies in the face. Davies lost consciousness, hit the ground, and striking the back of his head on the concrete. And he died nearly a month later, never really left the hospital. Well, Seymour maintains that he didn't actually punch Davies, but rather pushed him. Either way, it doesn't matter now because Seymour has been found guilty of felony murder, faces up to 30 years in prison. So our talkback question tonight, we want to know your thoughts on the verdict in the tattoo punch murder trial. Still with us to discuss, criminal defense attorney, personal injury attorney Samantha Vacciana, and law enforcement and litigation expert Sonny Slaughter. All right, ladies, our first comment comes from Debbie. Debbie says, put that guy under the jail. He had absolutely no right putting his hand on him. Yeah, and again, Samantha, I go back to my feelings about this one. It was a bar situation that we've all seen, you know, throughout the years. It's unfortunate that this man died because of this punch. This jury has found him guilty. There's just something about it, I feel like, sending this 65-year-old guy away for 30 years, I don't know, it just feels off to me.
I'm with you, right? I'm not with the 30 years, but I do think that, as my colleague said earlier, actions have consequences. And if you don't like what someone has, what they're wearing, what they look like, whatever, you don't get to just punch them. So yes, I'm sympathetic, right? I don't want him to be sentenced to 30 years. I think that's excessive, even though someone died here. But at the same time, I think that he needs to be punished.
Yeah, I agree. All right, our next comment comes from Brian. Brian says, you cannot claim self-defense and not testify. That's the way I felt about this one, Sonny. Again, I just felt like there was room and not much to lose if Seymour decided to testify.
I agree. He had not only did he have the opportunity to testify, but he also has the right to testify on his own behalf. You know, we saw the video, we've heard the other testimony, and if you have something to say, then the only time that you get to say it where it matters is when you get to tell your truth on the stand, and he didn't do that. So we can only go by what we know based on what was presented, and that apparently was not enough.
Yeah, it was all on video, though, you know. That I think with that video, you needed to talk about what was on your mind. I just felt that way. Our next comment, it says, basically, Seymour is everybody's worst nightmare. I hope he spends many years in prison where he'll see many men with tattoos. I love that comment because I would bet $1 to a donut, Samantha, that he's not going to walk up to anybody in prison and say, you're going to hell because you messed up something that God created.
For his sake, I hope not, right? But again, yeah, he's probably not going to do that.
Sonny, karma, though, you know what I mean? Karma can be pretty rough. If he walks up to somebody in jail and says something like that, he could find himself in a whole heap of hurt.
Although that's not what's going to happen. The karma is going to be that when he gets out of prison, he's tattoo that he got while he was in prison.
Oh, fair enough. I wonder if in jail he might decide to get a couple of tattoos himself. You know, that happens.
They gonna help him out. They gonna help him out.
Yeah, they'll help him out a little bit, right? Our next comment comes from Patricia. Patricia says, thanks to the alcohol and the ignorance, one man is dead, the other one deserves life where he can pray for forgiveness. And that's sort of something we haven't talked a lot about, Samantha, that alcohol played a real role in this. And I thought a couple of times in the video, even the victim appeared drunk to me and appeared a bit aggressive.
Yeah, alcohol definitely played a role in this. You're in a bar, you are egged on by alcohol, and then you have someone who's convinced that this is some kind of degradation against God. So all of these things put together. But yes, definitely alcohol was a part and played a significant part, I believe, in this case.
Sonny Sauter, quickly, will the alcohol 0.27 drunk under as far as, or intoxicated as far as Wisconsin law is concerned, will that be any sort of mitigating factor in sentencing?
I hope that his defense attorneys can argue that that is a mitigating factor and maybe get him, I don't know, reduced time. I don't know, but I think alcohol played a part in all of this.
All right, let's go quickly to our last comment from Vanessa. How dare he judge that young man for his tattoos? I agree he's a bully, and the fact that he hit Josh and left him on the sidewalk to eventually die. That's exactly what he did. He ran away from the scene, eventually lied to police about what happened, or it appears he lied to police. All right. Thanks to Sonny Sauter and Samantha Vacchiano for being with us tonight. Ladies, really appreciate it. We'll see you again soon. Thanks.